I'm Mike Erdman. I am the CEO of the Home Builders Association of Marion and Polk Counties, and I want to welcome everybody on behalf of our association, the Home Builders Association of Metro Portland, and a number of the other home builders associations around the state to the Escalation Clause webinar. As lumber prices have increased rapidly in the last number of months, I've gotten a number of calls from both builders who have been asking about escalation clauses and how they might use them, but also from homeowners on occasion who have said they have been asked by their builder to use an escalation clause. And in some of those cases, it's an entirely appropriate way of doing it. In some cases, unfortunately, we've been aware of builders perhaps that have tried to force an escalation clause after the contract has been signed. So it's kind of shown there's this need for the information as to how do you use an escalation clause and how do you use it in such a way that you don't get yourself in legal hot water. And so a great opportunity this morning, actually this afternoon, I guess, to welcome Hunter Emerick. And Hunter is an attorney here in Salem with the firm of Saalfeld Griggs. His specialty is in construction law, so brings a tremendous amount of expertise. So I'm going to turn this webinar over to Hunter. One thing I will ask you though as we go along, if you have questions during the webinar, we ask you to use the Q&A feature of Zoom webinars. And so on your screen there, you should have a Q&A button. And if you post your questions there, we can keep track of them and hopefully address them either as we go along or at the end. And so please do that. Please don't use the chat feature, use the Q&A. So with that, Hunter, I'm going to turn the webinar over to you and you'll take us away.
Hey, thanks, Mike. I really appreciate the opportunity to talk to everybody. And we have a great relationship with the Home Builders Association and really appreciate and enjoy that relationship. Today, I'm going to talk obviously about escalation clauses. I'm going to go over a little bit of material that you guys are living already. And so I'll go through that quickly, but there's some slides I want to show you real briefly that are really pretty remarkable in terms of the increase in pricing. Really, escalation clauses are a risk allocation issue, so I'll talk about that a little bit. There's a number of different strategies for reallocating the risk of cost. I'll talk about a number of them, obviously focusing on material price escalation clauses. I'm going to go through how those work and give you some ideas about alternatives for that. And also I'll talk to you about not only material price escalation, but also, and might kind of set this up a little bit, the idea of value escalation for residential homes and how you can and probably cannot deal with that. There are some statutory provisions that might be implicated if you're not handling the handling the value increases appropriately. And that's called the Uniform Trade Practices Act. So I'll get into that as well. So that's kind of the outline for today. I'll keep moving along, and certainly if you've got questions or thoughts, as Mike indicated, please use that system to throw those out so we can make this not just a talking head kind of presentation, but something that you guys have some input into. Okay, so let's get started. So I don't need to tell you this, prices are out of control. I pulled up some material from the National Association of Home Builders, their chief economist. His work shows that as an average price increase, he's looking at a $38,000 or $35,000 increase on new family single homes. For multifamily homes, his analysis was the average increase price was almost $13,000. That's being driven by a number of things. I know you guys know all of these. There's single family housing starts are up 41% in March year over year. That's the national number. Obviously, the pandemic screwed everything up with production, from lumber to nails to anything you need to build a house. It messed up with the production and also transportation as well. And of course, we had some tariffs that increased costs of imported lumber. But you know, it's not just lumber, it's all sorts of materials. And again, my source on this is the National Association of Home Builders economist. He's got drywall up 7% from 2020, steel up 18% from 2020, and copper up 27% from 2020. So these are really remarkable and really, frankly, in some ways, shocking numbers. And let me pull up the screen here real quick and share with you my, if I can find this, I had it just up here. There we go. Okay, we're going to get into, hopefully you're all seeing that right now. The AGC has some of this material, and this is a screen I stole a snapshot from this morning from the AGC showing inputs to new residential construction March over March 20 to 21 up 14%. And then if you go to this other graph that I've got, which is from essentially the St. Louis Federal Reserve called FRED. They've got producer price index by commodity, net inputs to residential construction, just goods, up significantly. And I did the math on that, and it's really remarkable. If you look at, you can't tell from that graph because you have to have the moving slide on that, but on the moving slide, the index for new construction inputs in January 2021 was 240.2. In March, so just 3 months later, it moved up to 252.6. So that's a 5.2% increase in 3 months. That's really dramatic and remarkable. And I know you guys are all suffering that right now. So how do we deal with that is the big question. And I know there's a lot of interest in this right now. And I think if you think a little bit more broad term, I worry obviously a lot because I'm a lawyer, but I worry about other things like inflation. And when you see these kinds of numbers and you see the costs that we're paying more and more on labor to induce people out of unemployment to work, I'm worried that this is becoming more of an issue that we're going to be looking at for a long time. So figuring out how to allocate these risks is going to be really important. Residential construction tends to be priced either at fixed fee or in some really rare situations, cost plus, gross maximum price not to exceed. And certainly in the fixed fee and the cost plus with the gross maximum price, the only person that bears the risk of increasing cost, either labor or material, is the contractor. And so obviously in this environment, that's an uncomfortable place to be for a contractor, taking that additional risk that historically we haven't seen quite this significant of a jump in prices. So what are the strategies to reallocate the risk of increasing cost of inputs? I've got essentially 5 strategies. All of them have pluses and minuses. Probably the best one ultimately is the material price escalation clauses. We'll deal with that last. But the general strategies that are out there and available are as follows. 1, restrict the timing on bid acceptance. 2, get deposits for material purchasing to lock down pricing and availability. 3, put restrictions on commencement of construction and when the construction must be started by to hold the contract. 4, cost plus pricing without, a not to exceed or gross maximum price. And of course, material price escalation clauses. And these issues really are both for general contractors and subcontractors. Obviously, the general contractors with their relationship with owner for the overall price of delivering the home or the residence, but also for subcontractors in negotiating with the general in terms of what they will deliver on their particular scope of work. So let's break down some of those different strategies on risk allocation. The first one is restricting bidding timing. And so that is just in your bid or in your contract, saying that the price is only valid for a limited number of days. And if the bid or the contract isn't accepted within that period of time, the bid or the contract is not valid, and the person providing the bid or the contract can reprice. There's a number of forms out there that include this, and a lot of times we don't use these provisions because we haven't been in such a volatile pricing environment. But certainly, as we are experiencing now, having something like that in your bid is helpful. It certainly isn't, the be all and end all in dealing with this risk allocation, because of course, even if you have the bid accepted and performance isn't required for some time, the contractor or the subcontractor still bears the risk of price increases after the bid acceptance. So another strategy to deal with that would be to require, as part of the subcontractor, the contractor, that you have paid deposits either by the owner or the contractor to allow for acquisition of the materials at that time. And it allows for the price to be captured that way because you're actually acquiring the materials as the contract is let. Certainly that caps off the problem of price increases, but it isn't a completely satisfactory solution because you have all sorts of issues. Then you've got materials that you may not need for months. You have to figure out where you're going to store them. You're going to have to pay for the cost of storage. You may have to transport the materials more than once from the warehouse where they came from to the storage out to the job site. That's an additional cost. You have insurance issues with taking control and ownership of these materials prior to the commencement of the construction that could put you at risk if the materials are lost. And certainly you've got the problem with changes in specifications or designs that happen during construction that may make the materials that were acquired up front not relevant any longer. So restricting timing on bid acceptance and obtaining deposits and purchasing materials up front are okay solutions. They have their own problems. The other solution is to restrict timing on commencement of construction. Again, this one helps subcontractors a little bit more than maybe contractors, but you'd have a provision in your bid or your subcontract agreement that says, if we don't get started on this project within X period of time, we terminate the contract, okay? That helps you on pricing because it doesn't draw the construction term or progress out too long. And so it minimizes the time period where prices might increase. But of course, it's not a really great solution to terminate a contract and have a hole in your schedule when you're planning on doing work, particularly in this environment when there's so much work to be done. So it's not great. And really, that provision is only going to work really very well with an escalation clause that we'll talk about in a little bit longer. The fifth one is cost plus pricing. I see cost plus pricing occasionally in residential construction settings, but it's certainly not something that is usual. And usually if I get a cost plus price contract, it has a not to exceed provision or a gross maximum price because it's just hard to convince owners that they should give you a blank check to build the residence. And of course, once you go into a not to exceed provision on your cost plus pricing or a gross maximum price cap, it just pushes the risk of the price increase back onto the contractor. So these initial ones have some advantages and certainly you can use most of them in combination with the material price escalation clause, but really the best solution is a material price escalation clause. Most of you that have been in the business for a while have learned a little bit about contract theory. And that was certainly part of my education as a lawyer, and I know it's been part of your education as contractors. But let me take a minute and talk to you a little bit about contract theory so you can understand some of the advantages and some of the disadvantages in material price escalation clauses. The first one is, I think we all recognize intuitively that when you have a binding contract, both parties are required to agree to modify, amend, or change the contract. And so once you have a valid contract, you can't change it. All right. You have to have consent on both parties. And we all intuitively understand that. In fact, that's what change orders are about. A valid change order requires both parties to sign off on the change order because it changes the contract, it amends the contract. It either changes what the contractor has to do for the scope of work, or it changes the price because of that work, additional work, or it changes the time period. So without an agreement by both parties, you don't have an enforceable change order or enforceable contract amendment. So that's really critical to think about as we move into the discussion of material price escalation clauses, is you have to have joint agreement to change the contract. Now, there's a little bit of a loophole in that general rule, I guess, and that is for material terms like price, you have to have the parties' agreements on the price or an objective method of determining the price. Okay, so put that in layman's terms, we either agree that we're going to pay X percent for the house, we're going to pay $400,000 for the house, or we have an objective method for determining the price. An objective method allows the court, without speculation, to set a price term or set some other critical term of the contract. But if you don't have a specific agreement by both parties or an objective method which would allow the court to calculate the intended price, you don't have a valid contract or a valid amendment. And that's really what the material price escalation clauses are trying to do. So for your specific price, obviously a specific price is your fixed fee or cost plus gross maximum price not to exceed. You know, cost pluses are just pushing through the cost of the performance by the contractor, usually adding on a percentage for the contractor's fee or maybe a flat fee for the contractor's fee, but then saying regardless, that cost plus the fee won't exceed this particular price. So that price provides the court an objective or specific price to work from. The objective method on setting price would be a formula that is pretty much set forth in the contract or a third-party appraisal. So again, keep in mind that essentially a price escalation clause just allows an adjustment to the contract price based upon an objective agreed upon method or metric. So for example, you know, your measure or your metric could simply be the difference in the price for a particular item quoted at the time of the contract and the price of the material when it's purchased for, you know, use on the job site. But you have to have that language in the contract in the escalation clause to allow that for that to happen. So there are a number of different material price escalation clauses. One is called a day one escalation, which basically says, okay, once we sign the contract, any increase in the material pricing from the day of the contract execution to the day the materials are purchased, any increase is going to be passed on to the owner. And that's typically shown, and we'll look at, Mike's going to show a form for the National Association of Home Builders in a minute, but that's typically shown by identifying the materials, the key materials that might be subject to volatile price increases, identifying those in the clause, saying, you know, the date that you got the price, stating the price, stating the vendor for, or the supplier for that material. So in the contract, you have your base price is set. And then when you go to purchase the material to perform, if that price is exceeded, you provide a notice to the owner and say, or in this another case, the contractor, you say, okay, you know, we had the lumber at X price per lineal foot. It's now X plus 3. So you got to pay us the plus 3. Here's our notice. Here's what the markup, the increase in the price is going to be for your day one escalation. And it's just a flat, complete pass through of that additional cost. If you have that clause in the contract, it is enforceable and allows you to increase the price. The other type of escalation provision is a threshold escalation provision. It's the same concept where you have what are our key materials that might be subject to volatile price increases. You spell them out, you identify them in the contract, you set your pricing that you're purchasing or you bid on, you set where you got that and the date you got that material increase, that material pricing. And then when you go to perform, when you go to purchase the material, you essentially say, well, if the pricing exceeds a certain percentage of upswing, we will charge you the extra over that percentage. So for instance, we're going to say, you know, if we have more than a 5% increase in price upswing, we will charge you the extra over that 5%. Essentially, in that case, the contractor saying, I'm willing to absorb a certain amount of material price increase before I pass it on to you, the owner, or in the situation where you got a subcontractor to the contractor. So the threshold escalation it modifies the risk allocation just a little bit. It says to the owner, the contractor, I'm willing to absorb a certain percentage of upswing in pricing, but once it exceeds that threshold, then you're going to pay for that extra, okay? The other type of escalation clause is a delay escalation clause, which kind of goes back to the other discussion I had about having a commencement provision in the contract saying, if the contract doesn't get built or we don't get commenced on the project within X period of time, we're out. This delay escalation clause takes that concept and says, okay, we are going to agree that we'll hold our price, okay? But if the construction isn't commenced on schedule and the price increases over that base price item that we had, then the increase is going to be passed through to the owner. So essentially, it's again modifying the risk allocation a little bit more to say, look, if we stay on schedule and everything moves forward, the contractor is willing to absorb the cost increases if we're on schedule. But if we go off schedule and the price increases for our materials, our key materials, then the owner pays for that. So there's basically 4 general types of material price escalation clauses. The day one, which is the most favorable to the contractor, that basically just passes through all expense increases of the key materials regardless of what's happened. The threshold, which kind of modifies that risk allocation a little bit, that says the contractor is willing to absorb a certain amount of increase, but once it gets over that threshold, then the owner pays for it. The delay escalation, which is you stay on schedule, I'm going to absorb cost increases. If we go off schedule and the price for our key materials increases, then owner or contractor, you're going to pay that increase. Now, all of these, the day one, the threshold, and the delay, really are dependent on identifying the key materials that might be subject to volatile price increases, okay? That's great if you know what the key materials are that are subject to volatile price increases. And as I talked about at the beginning of this session, the price increases are all over the board. I mean, drywall, copper, steel, everything's going through the roof. And so it's pretty hard. And when Mike shows you the form, you'll see this really clearly. It's pretty hard to identify every building component and set the base price on every building component. So one solution for that is have an index escalation clause or indexed escalation clause. And that essentially says, I'm going to set my price based on an indices or an index that says, if this key index moves up a percentage, okay, the price across the board is going to go up a percentage to match that index. The index I showed you at the beginning from the Federal Reserve is one that you could use to show when we contracted, here's what our inputs for goods were. That was what the base index was. If we get to the point where we're performing and that index is increased, we're going to look at that increase to be applied to the contract price and increase the price. That's a little bit more nuanced, and you don't see those out there in the industry very often. But if you do that and you use a proper indices, and certainly, the AGC or the National Association of Home Builders or the Federal Reserve indexes that are focused on building materials and inputs for residential construction are pretty good ones. That certainly would be an enforceable provision. Mike, do you have a minute to pull up that National Association of Home Builders form so we can show everybody that?
Yeah, so Hunter, I actually just shared that in the chat screen, so folks can call that up. But
oh, okay.
Yep. If you want to share that, you could share that. Otherwise, I can probably do that myself here.
Oh, either way, do you want to do that?
Why don't you go ahead, just because I
Okay.
haven't got that keyed up on my screen right now. I can get it if you don't have it handy, though.
Yep, I got it here somewhere. I just got to scroll through to where it moves around every time there it is. Every time I use it, I have to find it in a different place. Okay, is that showing through all right? Okay, so this is the National Association of Home Builders escalation clause for specified building materials. And as I indicated, it is one of many forms out there. I grabbed this one because it's the National Association Home Builders Clause. This first paragraph, or the first part of the first paragraph, really is kind of fluff. It's trying to explain to the homeowner why we're doing what we're doing on the escalation clause. The critical language really starts with let's see, 1, 2, 3, 4, 5, 6 line down, which starts with specified materials. So really it's the 5th line. It says, but should there be an increase in the prices of these specified materials that are purchased after execution of contract for use in this residential construction project, owner agrees to pay that cost increase to the builder. Pretty clear what we're talking about. That only works though if you have, as I scroll down, hopefully you guys can see this, the specified building materials listed, okay? And as I indicated earlier when I was talking generally about these provisions, you'll want to list your materials that are subject to the price increases: lumber, concrete, steel, whatever it is, your current price per unit of measurement, the date you set that price, and who you're getting the product from. And then when you go to buy the product for that project, you have to keep track of who you bought it from and what the pricing was for that. And if it's a substantial enough increase that you're going to want to pass this through, then you provide to the owner a written notice saying, look, here's the lumber price that we contracted at. Here's the lumber price that we're buying at. It's X% increase. And so I've got to increase my contract by that percentage to cover this lumber cost. This provision that the NAHB provides is essentially that day one provision where as soon as I go out to buy the materials, if there's been an increase, I'm passing that increase through on the contract price, okay? It's not the threshold provision, it's not the delay provision, but this is a pretty basic one that I thought was helpful to demonstrate what we're talking about with an escalation clause. There are parts of this I like. It's pretty straightforward. I think it makes sense to most people. It limits the areas where from the owner's perspective, the owner, can say, okay, I know what I've got in terms of exposure on price increase. And it really is pretty, in a sense, pretty fair, because it's hard for an owner to say, well, no, that's a risk you should take, contractor. I shouldn't take that risk, because ultimately it's the lumber or whatever component that's going into that person's home that's increasing the price. And if that doesn't get adjusted, the contractor is going to eat that cost, and that doesn't seem very fair. The part I don't particularly like about this form is this special circumstances right of termination. I'm not going to read the whole thing to you, but essentially what it does is it says, if the price increases the total contract price more than X%, it allows the owner to terminate, okay? And that just doesn't, I can't imagine that's going to work very well for most contractors, because particularly on a custom home, if you're partway through and you have this price increase and you pass that down and the owner terminates, that's just not a good outcome for you. And it goes on further that allows the builder to terminate if the owner doesn't agree or respond timely enough. So to me, this right of termination is a little bit of an awkward way of handling this thing. I think what they're trying to do here is basically sell the idea to the owner that there's an upside cap to their risk for this kind of price increase. For me, the better way to go at that would be to do a couple of things. First off, I really like the idea of the threshold escalation, which says as a contractor, I'm willing to absorb a certain amount of a % increase in my key component materials, but over that, you've got to pay for it. And so it puts you both in a relation where both of you are taking that risk, and that seems intuitively fair. The other way that if you're having pushback on the escalation clauses is to talk about mutual pricing, and basically say, you will have to pay for the price increase on these material components, but if there's a price decrease, that's going to reduce the amount you pay me for the project. And so it allows the contract price to be adjusted up for the increase in materials, or adjusted down for the increase in materials. And ultimately, that seems to be a very fair way of going at that. So I've kind of gone through all the material price increase issues I'm going to talk about during this seminar. The rest of this, I'm going to talk about home values, because as Mike indicated, we've had, both Mike has shared with me some inquiries from homeowners about contractors looking to increase the total contract price, not so much because of increase in component building materials, but because home values are appreciating so fast. And there have been some discussions about whether or not that can be done or cannot be done. If it can be done, how can you do it? And what are the risks if it cannot be done and you're doing that? So now I'm moving away from the idea of a component building material price increase going up and how to modify your contract to allow for that lawfully, to a question about, well, if I contracted to deliver the house for $450,000 in January, and by the time I finish that in June, if that house as built is really worth $500,000, I, as a contractor, just gave away $50,000 of value, and that's kind of painful, and I get that. So how do we deal with that? Okay, so the first question is, if you are in contract, in a binding contract, to build a house and provide a house on a closing date at a set price, again, my example, $450,000, can you go to the buyer and say, hey, market value's increased, okay, and that house is now worth 450, I mean, worth 500. So the 450 I contracted for you, I'm not willing to take anymore because I just built you a house that's worth 500. I want you to pay 500 because that's what that house is really worth. If you have a binding contract, as a matter of contract law, you cannot do that. Okay. And that's assuming you have a binding contract. But, you know, if you're following the form and it's properly filled out and you've got a stated contract price and, you know, everybody signed everything, you probably have a binding contract to deliver that home at 450. And if you go to the party and say, I want 500, the party cannot be forced to pay 500 unless for some reason they agree to pay 500, which of course it's unlikely they will do that. Okay. It's possible that we could write a contract that would allow for that. We'll get into that later. But I want to talk a little bit more about if you come to a owner or your purchaser of the contract of the home and basically say, listen, you got to pay me another $50,000 for me to close on this because the value is increased by $50,000. Obviously, it's a breach of contract. If you have a binding agreement, the buyer in that case could refuse to pay the upswing. And if in that case, the seller or the contractor refused to close and deliver the house, certainly the buyer could sue, okay, under contract law and for specific performance, getting an order requiring the contractor to deliver the home and accept the 450. And if the contract has a attorney's fees provision, okay, and the buyer won that argument, which I think if there's a binding agreement and there wasn't an escalation clause, the buyer would most likely win, then the contractor is going to pay attorney's fees, reasonable attorney's fees for the litigation or the arbitration that ensued over the buyer's right to force the contract to deliver it at $450,000. The other issue that I think folks need to think about is the Unfair Trade Practices Act. And that's the statute here in Oregon that applies to the advertising, sale, or renting of real estate. Okay. It's under the Unlawful Trade Practices Act. And certainly when we're selling real estate or we're contracting to deliver a residence or a building that's going to be used for residential purposes, we're under that statute. And we don't talk about the Unlawful Trade Practices Act very much in construction law because we don't, unfortunately, if we're behaving ourselves, don't bump up against it very often. But when Mike told me we were having some homeowners complain to the HBA about this, I wondered whether or not there might be a violation under the Unlawful Trade Practices Act. So I looked at the statute, and there are no cases on this. It's just the statutory language. So I'll read to you real quickly the one section that concerns me a little bit. And this is section 608(1) that says that if you, in the course of selling, renting, or advertising real estate, advertise real estate, goods, or services, which would include construction of a home, with the intent not to provide the real estate, goods, or services as advertised, you violate the UTPA. Okay, so if you advertise a house at 450, you contracted for the house to be delivered at 450, and then you intended at that time to have that swing up with the value of the market and asked that the homeowner pay 500, there could be an argument, I don't have any cases on this yet, but there could be an argument that violates the UTPA.
So
And
Hunter,
yeah,
can I
Mike.
ask a question for clarification? Because we've had a couple instances where perhaps the builder went back to the customer and asked for more money, not because the value was going up, but frankly, because they didn't have an escalation clause in place at the time they signed the contract. And they signed the contract, now material prices are going up, so they're going back to the customer and saying, I need you to sign this escalation clause now. And they've gotten into a bit of a headbutt between the builder and the customer because this is all taking place during construction and well after the original contract was let.
Right. Same issue, Mike. And thanks for asking that question. I've been focusing this on value issues, but if you don't have an escalation provision in the contract for material price increases, you would be in the same, or could be in the same situation where you're saying I'm gonna provide it for 450, and because of material price increases, now let's say you're at 420, 475, you got a $25,000 upswing, you still could be, violating the statute. The real question to me is the intent. You have to advertise it with the intent not to provide. Um, if you advertise it at 450, not knowing that we're in an increasing price environment or an increasing value environment, maybe you could say, hey, when I advertised it at 450, I intended to provide it at 450 and things changed differently. So maybe you don't violate that statute, but boy, that's really getting cutting it pretty thin, because if you do that and you get sued for that, the homeowner just has to suffer an ascertainable loss of money or property, real or personal, and it may be the delay actually in moving into the home as a result of this dispute about what the ultimate price is. But if ultimately you back off of that demand that they pay the upswing when you don't have a good basis for that, it's possible that they still can state an Unlawful Trade Practices Act. And in that case, they get statutory damages of $200, which is, who cares? That's not a lot of money, right? But they get punitive damages and attorney's fees. And so, when you read the cases where people are filing Unlawful Trade Practices Act, oftentimes they are over very small damages, okay? Not significant damages. But what gets the plaintiff's attorneys excited about them is if they can show punitive damages and win, they get attorney's fees. So the attorney gets the payday out of this situation, which ultimately drives these Unlawful Trade Practices Act. So clearly, if you don't have an escalation clause, it's really at least a breach of contract that you can get sued over under your contract. And it may be an Unlawful Trade Practices Act violation that you don't want to get in the middle of. So how could we go about this? And then focusing back on the value piece, if we have a valuation increase that we want to capture on the contractor side rather than the owner side, can that be done? I think theoretically it can be done. The question is whether or not anybody would sign a contract that had this provision in it, but essentially it would be saying, listen, we're contracting to deliver you a home per the specs and plans at 450. But we're in an environment where valuations are increasing, and if at the time of closing that house is worth more than 450, you're going to agree to pay us the upswing, okay? And how do you get to that? Remember back when I talked about theory, you have to have a set price or an objective basis for saying the price. And certainly if you said in the contract, it's 450, but for example, if we have an appraiser and you name the appraiser, or you had a mechanism by which both parties agreed to select an appraiser who came in and said, nope, that house is now worth 500, not 450, if that appraiser sets it at 500, that's the price that will be paid. And if you have that language, and if you can get somebody to agree to that, then yes, you could capture that market uptick in the value of the house. You could also do that on some form of index that prices, follows the increasing value of home or increasing value of residential construction that ties it to that index. And if it was set forth in the contract, you certainly could do that. Of course, the problem is getting consumers to agree to an open-ended contract like that. Certainly, if I was a consumer, I would say no thanks, or at least I would want to have a cap on some up end of that. Or maybe I'd want to say, well, that's fine. If you want to swing it up, I want to swing it down. If the value turns out not to be at 450, then you agree to take 425 or whatever the number is set by the appraiser. And of course, you also have issues with whether or not you're going to get the property or project financed, because I'm not sure that lenders, I've never talked to a lender about this, to be honest with you, but I'm not sure that lenders would be real thrilled about trying to figure out how much money they're going to lend on a project when they don't even know what the purchase price may well be. So that's my presentation today. It's an interesting area, and it's become more interesting because of these prices that we're really seeing happen. I hope that was helpful to you. And I don't know, Mike, are there any issues we need to address before we call it quits today?
Yeah, so Hunter, we've already got a couple questions, and I can go through them one at a time. And then if others have questions, please ask them in the Q&A, or if you hit the raise hand button, we can take them verbally. But the first question, Hunter, is: are there only certain points during a contract that you can use an escalation clause? Materials, of course, are purchased at all different points in the project.
Yeah, no. So you're going to have to do it at the front end of the contract, and that's a great question, because it sounds like I didn't explain this really carefully. So at the front end of the contract, when you're signing the contract, you're going to have your materials identified in that clause that says, here's all the component building materials that we're going to need to build your residence, and that we think are subject to price escalation. Okay. And we get the value for them. And that's our day one. That is as of the date we contract or immediately before. Okay. Then as we purchase the very different materials that are identified in our base, okay, then as that purchase occurs, you marry up what the base was versus the actual purchase price, and you look at that increase. And if there is an increase and you have a day one escalation clause, that amount of increase gets added to the construction price, the contract price. And I saw I don't know if I know how to pull this up, Mike, but I saw a comment about, no, this was really an enforcement question. And yeah, I was able to pull it up. So enforcing the clause, do you do everything at the end? Yes, I would do it at the end, because in your final purchase price, the final adjustment on your purchase price, you'd want to do that at the end. Because of how most progress payments are set up, I'm not sure that would work real well by throwing in a piece here for lumber, a piece here for copper, whatever it might be. It would be better to do it at the end. Just administratively, if you wanted to do it going forward so that you made sure that there was enough contract money available to you at the end, you could do it going forward, but you'd have to probably change your pay provisions on how progress payments are calculated. So that was addressed in the contract as well.
So Hunter, we've got one more question. It says, in the contract, when you're identifying the materials in that escalation clause, can you say framing lumber or framing package, or do you need to specify the cost of 2x6 studs and your 7/16 OSB, et cetera? How specific do you need to be in laying out the materials?
That's a great question. And certainly what I've seen has been more specific rather than general. You're not going to get in trouble by being more specific. If you can't get that level of specificity, or if it's too much of a headache, If you have a framing package that you say for your project, here's the framing package, and you can define it to be, all the framing lumber necessary to put the structural members in place. And then once you go to purchase that package, you've got a price escalation that'll work. It's really the real critical thing is, are you able to define it clearly enough at the front end of the contract that when you go to purchase that particular item, you've got apples to apples. So there's no question that what you said was, $10 a square foot at the beginning of the contract is now $12 a square foot. So there's no argument that this $12 a square foot is including something that wasn't in the $10 square foot. So it's really a question of, does the framing package define it clearly enough so no one's going to be arguing about whether or not it's apples to apples?
So Hunter, a follow-up to that question is asked, and that is, do you need to specify all of those prices in the escalation clause, or could you simply refer to them and say, see attached for the lumber bid?
Yeah, you could attach the lumber bid. There's no question about that, as long as you do one thing, and you make an exhibit to the construction contract. I mean, you have the escalation clause that says what happens if this increases, like we showed you with the National Association of Home Builders, and you said our component building materials are attached in the bid from whatever supplier, and the bid is exhibit A to the contract, and that exhibit is attached to this contract and incorporated herein by this reference. It's kind of the magic language to do that. So that would be certainly appropriate if you attached it as an exhibit and referred in the escalation clause to that document as what's setting your base price for those particular products. That would be a quicker way to do that.
Okay, Hunter, Dan Dorn's asking, is an allowance for certain line items acceptable? Lumber, labor, et cetera.
Of course, Dan would come up with something like that. Certainly we all get away with allowances, okay? Allowances are dangerous. We all do them, but they're dangerous because what we do is we set a budget price, right? Here's what we think we're going to give you for, flooring, and you go out and pick your flooring, and if it comes in higher, you're going to pay us that X%. All right. I think the problem that you're going to run into doing that, Dan, as an allowance is, at least the consumer has the ability to swing that price one way or the other by selecting a less fancy flooring or a more fancy flooring. And they know that that's going to have a certain outcome to them when they do that, and they have some ownership of that. But if you do that as an allowance with, components where they've got nothing to do with that, I'm not sure that that's going to work the way you want it to work, because you may, without having that base price and having the agreement they're going to pay for that upswing, I'm not sure it's going to work the way you want it to. So I would keep allowances to materials that the homeowners have ownership over in selecting, and that drives their pricing decision.
All right, Hunter. Don Lule asks, do builders need to provide copies of invoices of cost before and after?
Well, ultimately, you may have to. The law doesn't say that, and certainly this is all common law. There's no statutory provisions other than the UTP I mentioned earlier that really drives this. But certainly, if you're going to come in like with the National Association of Home Builders form, where you put in your pricing, and then when you have an increase on pricing on that particular component, you say, here's my increase. If the homeowner says, I want to see it, you're going to be hard pressed to say, no, I'm not going to provide it to you. So I think you do have to be prepared to provide that. And that may mean, in terms of how you're doing your internal pricing, whether or not you're marking those materials up, you may want to think about pushing your contractor profit or overhead into a different category than a markup on some particular building component.
So that is it for the questions we've got so far. Before we wrap up, if anybody has anything else, you could always hit the raise hand button and we can unmute you. I'll give that just a few seconds. Other than that, I think we're just about wrapped up. I want to thank Hunter. A lot of work goes into these presentations, and so we appreciate his time and willingness to come and present this for us. So I hope you guys found it very informative. We will have a recording of this webinar posted to our YouTube channel by tomorrow morning. And then hopefully you all saw in the answered Q&As, we had links both to the slides. Somebody asked for the graphs, and also to the escalation clause itself. So that is it. We do not appear to have any other questions. So we are wrapped up. Thanks to everybody for coming. And once again, thanks to Hunter at Saalfeld Griggs.
Hey, Mike, thanks for the opportunity. It's always great to talk to the members. I appreciate it.
You got it. All righty. Take care, folks. Thanks.
See y'all.